Hi, this is Delegate Steve Aarons, District 36, representing Kent, Queen Anne, Cecil, and Caroline counties, and you're listening to the Maryland Association of Counties podcast.
Hello and welcome to the Conduit Street Podcast. Kevin Kinnally here with Michael Sanderson. Michael, excited for today's podcast. We have a really good guest.
Yeah, I'm excited too. I mean, we spent a full episode of our podcast a few weeks ago talking about MACo's legislative initiatives. We tried to do that sort of as a preview for the 2023 legislative session, and we did, I think, a fairly quick run through of the top issues that our legislative committee has adopted as our big issues for next year. And in talking through that, I think you and I felt like the one area that was worth some more conversation was, what are we going to do about body cameras, body-worn cameras for law enforcement officers and potentially other personnel in your local government? This is an emerging trend. It's happening in a number of places in Maryland already. It's on its way everywhere, and getting the laws sorted out correctly for that new technology is an interesting and timely topic for legislative action. We wanted to get more deep into that topic, and so that's our plan today is let's dig in a little more.
Yeah, certainly this can get pretty technical, but fortunately we have one of the best in the business to help walk us through the issue in a way that we all can understand, because again, it can get weedy. And we're thrilled to have with us Hilary Ruley. Hilary is the Chief Solicitor at the Baltimore City Law Department. Hilary, thank you so much for joining us and welcome.
Thank you so much for having me.
So I guess, maybe the first place to start off is the city solicitor's office is a little different title than most folks who live in county governments. Most of the counties have an office of law and a county attorney. The city solicitor has an analogous role, but can you, for our listeners' benefit, can you first explain what does the city solicitor's office do on behalf of the city of Baltimore and its residents?
Yeah, that's a great question. Solicitor isn't something you hear very much these days. It's pretty much Old English. Obviously, in the English legal system, you have barristers and solicitors were more the advice givers. So, harken back the many years ago when the city was formed, in still colonial times, that was sort of the go-to word for legal advice. And it's essentially what a county law office will do, give legal advice. And of course now, also, lawyers in our office do what a barrister would do. They do litigation work as well.
I think you're joined by Howard County, I think, is the only other jurisdiction in Maryland that has a solicitor as opposed to a county attorney, but basically the same function. So it's the chief lawyer on behalf of the local government. Got it. Right.
And so, there is the city solicitor. It's appointed. It's not elected like the AG. And it's basically, there's chief solicitors under him, more experienced lawyers essentially, and then assistant solicitors, more, new lawyers.
Right. So in your role there, you certainly wear a lot of hats. So tell us what areas you focus on professionally in your time in the department, and, what your focus is moving forward.
Right, sure. So in the city solicitor's office, there's lots of different departments. There's litigation, as I mentioned. There's a contracts group. There's a real estate, real property group of attorneys, others that do sort of more business transactions, and the group I'm in, which is advice and counsel. And so we kind of get more the advice questions. So in my particular role as a chief solicitor there, I've been there for maybe, almost 15 years now. We answered questions from city entities, legal questions. We also review city council bills that need legal review. And we review General Assembly bills when the General Assembly's in session that our clients asked us to take a look at. And sometimes I'll obviously testify in the General Assembly about a particular bill, usually on the Public Information Act, as you know, and often with MACo. Mm-hmm. And then I also supervise a full-time attorney who is dedicated to responding to Public Information Act requests. And among other lawyers in our office, certainly, we consult as we're sort of the go-to entity to discuss the form and structure of city government.
Right. So I guess it might not be obvious to all of our listeners, even though, this podcast veers in and out of county government and local government issues, but the breadth of things that a full service local government is responsible for. Like you mentioned, like all the different contracts with vendors and other folks who interact with the city government, that you have a section on real estate because you're owners of so much property. And I'm sure there are other things that come up in land records or whatnot, that there is a pretty major role for a law office representing and guiding the sort of leaders and policymakers in city government. But it's the last piece you got to is really the hook that we wanted to talk about today. You mentioned the Public Information Act. So that's what we want to speak about a little bit today. I think a lot of our listeners are probably maybe more familiar with the term Freedom of Information Act. You see that on television, or you may hear about that at the federal level with documents and federal agencies and so forth. And a number of states have adopted state-level Freedom of Information Acts. Maryland has done basically the same thing, but in our inestimable style. We have given it a different name in Maryland. So the name of our Freedom of Information Act is the Public Information Act. But the principle is basically the same, right? The Public Information Act basically says the government is a custodian of data and information and documents, but it effectively belongs to the public. So for the most part, if the public asks for those things, we should share them and provide them. But then there are some caveats and so forth. Is that more or less how the PIA works in Maryland?
Yeah, essentially every state has one. Some of them call them, some version of FOIA. I think New York is FOIL, Freedom of Information Law. So these are just acronyms for essentially the same thing. It's giving the public access to government records.
And in Maryland's PIA, can you walk us through a little bit about, so you've been a custodian of documents, and you said you supervise someone who's actively sort of governing PIA requests and responding to them and so forth. So can you give us a little bit of flavor of what that duty is as a custodian of public documents, generally speaking?
Sure. And let me be clear. We in the law department, we're the lawyer for the custodian. Okay. Certainly the law department is the custodian of its own records. My notes, our trial briefs, our deeds, our drafts. Of course, we are custodian of that. But I think it's important to remember every single record custodian has the duties under this law, and most governments are composed of many record custodians. So, for example, in Baltimore City, the law department is a custodian. The mayor's office is a custodian. The zoning board is a custodian. The public works department is a custodian. And that's important. So while I have a client called the mayor and city council of Baltimore, essentially Baltimore city government, it's made up of multiple record custodians. And under this law, each record custodian is required to respond to requests to view its records. And so there are many times, to be clear, that records are requested and it's really not a big deal. Could you please send me the map to City Hall? Sure. We put that stuff online. So that kind of thing, anytime you're asking for a government record, you're essentially using the Public Information Act because that's what allows the public access to those records.
Right. And so I guess as a practical matter, someone who lives in Baltimore and is curious how the city made a decision to why are you tearing up this street right now? What went into that? What were the working documents that made you decide you're going to do, repave or resurface this particular roadway? It's an inconvenience to me in my drive. I want to know how you reached that conclusion. They could approach, I guess, the city's Department of Public Works and say, I'd like to see the work papers that went behind that decision or things of that nature, right? This is the small ball kind of stuff that does happen under the PIA. People can say, I want to see how you concluded to do such a thing. Is that fair?
Absolutely. And I think, you've hit on what the PIA and all these state and the federal law is supposed to do. It's supposed to give the public access to the operations of government. And so that is generally the guidepost when looking at what gets released and what doesn't. If it's about how the government operates, if it's about how your elected officials or the government employees make decisions, that's usually what these laws seek to release to the public. Mm-hmm. And as I'm sure we'll get into, exemptions are usually there to protect things that really aren't about government operation. Things like someone's private, personal, financial, or medical information. So, the PIA law in Maryland and, of course, all of them, they're designed to allow the public to have access to, the workings of the government. What does the government do? But I think it's important to note also that it is a statute giving access to records. It doesn't entitle people to have some sort of give and take or the press an interview or a deposition. It doesn't entitle someone answers to questions. Mm-hmm. It just entitles people to access to the documents that exist. And that's both paper documents as well as electronic documents, emails, for example.
Yeah, and I recall we had to touch up some elements of the Public Information Act. I don't know, this may have been a decade or so ago. The idea of releasing electronic documents to people when they request it. I mean, I'd much rather have a sortable Excel table rather than a 35-page printout of data. And if you've got it in electronic format, we're obliged to provide it that way. But we don't necessarily have to share things like the metadata behind the assembly of the document, other stuff like that. So, I mean, there's precedent for sort of adjusting these laws to accommodate new technology. And let's put a pin in that because that's sort of the issue where we think we are right now. I do want to follow up on one thing you did mention, though, that there are exceptions. So we have a rule that more or less says public information belongs to the public. The custodians should provide it. But then you got into there are exceptions to that rule. And I think it's worth like a second or two to explain that. So if I walk in the door in Baltimore City and say, I want to know about the insurance company that the city works with to provide health insurance benefits for city employees, that's a public document for the most part. But if along the way there might be information about, well, we did a study on usage of different doctors or physicians or specialists by city employees, and we might have internal data that shows specific employees who use specific doctors or have specific conditions. That's exactly the kind of information that wisely, I think, Maryland's law says you don't reveal that to the public, that this particular employee is on kidney dialysis and is going for regular treatment A, B, and C. That might have been an incidence study that the city might have done for some reason for cost management, but that's not the kind of thing that you would share to the public and identify a person. That's the kind of thing we're talking about with exceptions, right?
It is. And I think you pick out an easily accessible exception here because, as I mentioned with the guidepost, there's nothing you learn about government operations by knowing about a particular employee's kidney issue. And that's really the difference. We're not trying to say that if you work for the government, all your medical and financial information is now disclosable to the public. That's not what this is about. The law is designed to look behind really government operations. If there's documentation about how the government made a choice, what the government spends, what it purchases, why, even communications between government officials about government business, that's the kind of thing we want to disclose. The exemptions are the General Assembly, and then, of course, in every state, they also have them. Essentially, the legislature's putting a line down and saying, these are the kinds of things we don't want the public to see, mostly because they have nothing to do with government operation.
Right. And I think that's the perfect lead up. We know that, how Maryland's law works generally. I think you've laid that out pretty well. And I think we've set the table for the discussion that we really want to have today, which is about body-worn cameras and specifically body-worn camera footage as it pertains to the Public Information Act. So, Hilary, we know that body-worn cameras offer a substantial advance in promoting accountability and safety in law enforcement for the public and for police officers. There's no doubt about that. And we also know that many states have separate laws for dealing with the release of body-worn camera footage. But for years, Maryland has struggled, and it has failed to enact a clear set of guidelines for releasing this footage under the state's Public Information Act. So for now, all the footage that you have recorded on body cameras is stored somewhere, and it sits there as a public document. Is that correct, Hilary? That's essentially what's happening right now, and we don't have a separate set of laws. You know, we have a law that says, hey, on a paper document, you have to redact certain things and whatnot, but we've never really gotten to the point where, hey, body cameras are different, and we need to have a clear set of guidelines separate from traditional Public Information Act laws to really govern the release here and to tell our custodians what they should be doing and really clearly define what should be released and what shouldn't be.
Yeah, you're absolutely right. And I think, you know, when we talk about exemptions from release, we're talking about a legislature in Maryland, of course, General Assembly, coming in and saying, this is fair game. We want the public to view this. And this is something we don't want the public to see. And I think this makes a lot of sense if you actually understand the way that the Public Information Act is laid out. It is laid out in Title IV of the General Provisions article of the Maryland Code, but it's divided into parts. Mm-hmm. And part 1 is just your background. But part 2, 3, and 4 5 as well. 2 through 5 talk about these exemptions. What kind of records can you not see? Because the default is to see them. And this, again, is both paper and electronic. And the way that this law is written, as most of them are, talk about really kind of paper. Part 2 is, which whole records can't go out. Part 3, what information in some records are not allowed out. And that's the majority of the exemptions, about 30 of them. And then part 4 is, well, what kind of information does the government have the option to let out or not? And the 5th is sort of temporary denials, which really is not relevant to this discussion. But when you look at the whole structure of the law, it was created for the concept of having a record and information in that record. Mm-hmm. And so it can grow and change. Email is an example. But when you start to get to video, it becomes really difficult to think of a whole video as a record. And then information in the video is like, what are you seeing? Little, frame by frame, picture by picture, even within a still photograph. What part of that photograph can be released and what part has to be blurred out? It gets to be challenging, as you were indicating.
Yeah, I mean, you can think this through already. I think we think of public records as like pieces of paper in a manila envelope in a file folder someplace, right? Like the old school public record. And people are familiar with the idea that you might get something from the government and there's sort of the black magic marker over names of specific people or other things like that. There, someone went through that document and you can read word by word and say, well, this particular piece of that letter should be redacted. It's not relevant or it's not appropriate to be sent to the public. It's one of those things in the sections of the federal FOIA or the state PIA. It's in those sections of law that say, generally release stuff, but not this kind of thing. So the magic marker on a letter to cover out, one sentence or one paragraph or whatever is what we're familiar with. But the idea of a public record meaning 3 hours of video footage from a body-worn camera is just a whole, it's an exponentially larger task to look through that and make judgments about what information is contained therein, right?
Well, yeah, and I think you hit the nail on its head. The way that the redactions are set up, there are many, many mandatory redactions. So, for example, the one that, Social Security numbers in certain instances, or somebody's bank account number, as well as medical information. You think about a record about, say, a dog bite. Someone calls into the city's 311 system and says, I've been bit by my neighbor's dog. and I'm bleeding and I'm uncomfortable and this is whatever. When you look at a printout of that record, it's our job as lawyers to note, okay, section 4329 of the Public Information Act says I can't let out medical information. So I'm going to redact that part that talks about the bleeding that occurred from the dog bite, because that's somebody's medical information. But I could let out the rest. Well, think now about the audio call. When you are calling into 311, there's an audio tape. That too is a government record. And now I've got to have the software and the ability to go through and listen to that whole recording. And every time the person mentions their medical or physical condition, I've got to find a way to like beep it out or redact it out. And the same is true with body camera. And so it just becomes very challenging from a tool perspective to implement that. But I'll say also, one of the biggest challenges is that many things are listed in the law that are required redactions. There is no debate that I have to take that medical information out. I don't have a choice. I don't have an option.
Right.
The person bit by the dog can't say, no. I can't wait for people to know how bad my injury is. You, government, you release that publicly. I don't have an option. There's no waiver. There's no consent. If they want to get a copy of their own call and release it themselves, they can. But the government has no choice. But there's a whole thing, a whole part of the PIA where the government has the option to decide what to release. And that may seem counterintuitive, but that's where the General Assembly is saying to the government, you have to look at what the release of this information would do and whether that's in the public interest. And so not only do you have the technological challenge of redacting things that must be removed, you also have the mental challenge of deciding what's going to happen if I release this. And both of those come sort of crashing together when you talk about body cameras, because both of those are difficult.
Right. And I mean, so I know it's fair to say that Maryland's PIA law, again, all envisioned for paper documents, similar media. It was never designed to address the practical, technical, and privacy challenges that come with body-worn cameras. And Hilary, I think something that you just said, giving custodians, giving local governments sort of that option of whether or not to release something that's not enumerated in law that needs to be redacted. I mean, typically at MACo, we're all about flexibility, and we want more flexibility locally to govern, and we want to have the option, and one size does not fit all, and we typically like that. But I think with body cameras, you're right, all that kind of comes crashing in with the technology, with the mental aspect of, hey, what do we do here? Should this be released? Is it in the public interest? I think that in some instances, it's fair to say, I think, that we would like a little bit more guidance and clarity on, hey, this is also a mandatory denial, right? Well, you can't release this. You have to redact that. And maybe we don't need so much leeway to make those decisions. And again, it's weird to say that at MACo. Again, we're all about flexibility, and we're all about having that option. And we think that's the best way to govern. One size does not fit all. But in some instances like this one, I think it becomes really difficult to make those decisions on the fly. And then you're ultimately accountable for those decisions too, right, Hilary?
Yeah, I mean, I think you've raised some really good points. To the latter, absolutely. In Maryland, the government employee, not just the government itself, but the actual employee, and in fact, any vendor, anyone, is liable for disclosing information that they weren't allowed to disclose, but also liable for not disclosing information they should disclose. Many other states don't have that kind of liability. And the liability is not just monetary. There can be criminal misdemeanor charges. So we take this subject very seriously when we're looking at how to implement the law. As I mentioned, many record custodians all coming to the law department for advice when needed. And it's, my job as a lawyer, and certainly one supervising another lawyer, to make sure we're redacting out the things that we're not allowed to disclose. Medical, psychological information, I've mentioned, home address and phone number of employees, or certain social security number information. There's whole records we can't let out if we were to have them. Everything from certain MVA records to certain firearm and handgun records. There's all these mandatory non-disclosures. And that can be tedious, but it's fairly straightforward. The law gives the government no choice. And it's because as a society, we've decided, the point of a government records request is to learn about the government, not to know about someone's personal, medical, financial information. But that isn't the sum total. And the permissible denials in Part 4 of the PIA law talk about allowing the government to withhold information that would not be in the public interest if released. Things like advice from a lawyer to a client. That might be something that's really worth protecting now. But if you're looking to see, what legal advice did William Donald Schaefer get 30 years ago, perhaps that's, of much greater historic value, and there's no reason not to withhold it. So the circumstances can come into play. And for body-worn cameras, we're in a world of investigatory record exemption. And basically, it gives the government a lot of leeway to determine when a record about a law enforcement investigation can be disclosed and when it can't be. And in Maryland, some of the enumerated times where you really should look at it is, are you compromising a confidential witness or source? Are you revealing publicly a technique that the law enforcement community really needs to keep secret? Are you putting someone's life in jeopardy? Are you compromising the investigation? And so that's what the government disclosure paradigm is. As you said, we always recognize that one size doesn't fit all. And so that's sort of the whole purpose of those permissible denials. It's not about protecting the government from disclosure of things that might not look good. It's literally about giving flexibility. When is it not in the public interest to disclose those things? And you can understand, it's not in the public interest to disclose the, suspect that you haven't yet arrested. You don't want to tip the public or the suspect off. I mean, that kind of thing is the flexibility we're talking about. It's when is it not in the public's interest?
Yeah, no, just one thing I wanted to get back to before we get too far away, and I know we're going to get into all these nuances, but, in Maryland, and you said under Maryland law, the individual, the custodian who decides, who makes that decision is ultimately liable, not just the government. And you mentioned in other states, that's not the way it is. I'm interested to know why you think that is the case in Maryland, and is there a benefit to it from your perspective to hold the actual custodian, the individual who made that decision, ultimately liable, and not just the government that they represent and they work for? Is there a benefit to you to do it that way? And why have other states decided to not do it that way?
I think other states have decided not to do it that way because it's really almost draconian when it comes to the reality that people are generally trying to do their best work, but they may mess up. They may, accidentally forget to redact somebody's medical information. They meant to. There was sort of no ill intent, but they're going along redacting and they miss it. So I think that it's not really the kind of thing that most states want to punish, and certainly not punish criminally. I can't speak to why Maryland's had it. It's certainly been in there for decades. It doesn't really heighten my review as a lawyer because obviously I'm a member of the bar and certainly want to continue to have my license. So it's not exacting from me any higher scrutiny. But and it hasn't, to my knowledge, been used all that frequently in Maryland, although it has. But I think it's important to understand that while that still exists, most government employees are very leery of making a mistake. And I do think that it results in very slow and very methodical review by conscientious employees because that is lingering out there. They don't want to get, don't want to get in trouble.
Sure. And Maryland's law being structured that way. I mean, it's technical. You default to sharing. Then there are several areas where you are not supposed to provide the record. And the state asks the custodians effectively, you need to bat 1,000 here. So that's a pretty high bar. I agree with you. I want to follow up now and talk about kind of the nuts and bolts here, because it's body worn cameras are the issue of the moment. And we've talked a little bit about how, the piece of paper has a name or a social security number or health information or something, and you redact it with the old magic marker. You talked about an audio file where there's sort of a linear conversation. You might have to beep out words or eliminate certain words or whatnot. But that's fairly, linear information that you can evaluate what's in it a lot more readily than you can with footage from a body camera. So to me, that's where this whole law is missing a pivot. And this trend is underway. We know, lots of officers in Maryland that are employed by local governments, including the city of Baltimore. Lots of places are using body cameras already. And we've been working with a coalition of advocates to try and bring some balance into these laws. It's tricky. You run the risk of sounding like you're anti-transparency, but I think to try and illustrate that, let's walk through the kind of stuff that can be in the footage on cameras. An officer goes into somebody's home and is looking around, or is responding to a domestic violence call, that sort of thing. So now the victim's face, maybe children's face, objects that are around somebody's home, all these things are captured in the background of body camera footage, in addition to just what this person did or what this person said, or what the suspect did and so forth. The things we think of as the centerpiece of the camera footage, there's just a lot that can be there as ancillary stuff being picked up by a video camera. They're just an all-seeing eye, right?
Well, yeah, and I think you've highlighted the difference between a police report, where you're literally reporting on the information that's important to the police. Who was there, what happened. The police report's not going to say, oh, and by the way, turns out all of the furniture in that house is really ugly. Just saying. There's no background. There's no tableau. It's sort of the classic just the facts. But more than sort of the, quote, embarrassment of having a camera in your home, looking at your stuff in the background, like you mentioned, children there. Also, domestic violence, certainly, you could have right in view a person who's injured, a person who is, physically or mentally scarred, a person who's suffered trauma, or all sorts of things. And so when you're talking about police records on paper and you look at the investigatory exemption that the PIA provides, it's a little bit easier. When you look at the list of things that you may redact, is letting this out going to interfere with the law enforcement proceeding? Essentially, has the arrest been made yet or not? Is it going to deprive someone of a right to a fair trial? Is it going to disclose a source? You can sort of go through. If it says, by the way, we got this tip from so-and-so, that's an easy redaction. It's much harder on a video to know, okay, is the guy in the background that tipster we always use? Should I be blurring his face out? What do I do? But even those sort of technically difficult things to do because it's video and not paper are kind of massively overshadowed by something you were hinting at when you were discussing, the unwarranted invasion of personal privacy. Yeah. That is sort of classically it. Section 351B3 of the PIA basically says the government may choose not to disclose a part of a record because it constitutes an unwarranted invasion of personal privacy. That's something you're just not getting in a police record. You're literally getting only the stuff that's relevant. In a body camera worn, footage, you're seeing the whole tableau, the whole background, all sorts of information that you would never get in a paper record. And it's incumbent upon us, like you said, to make that distinction. And I think that is probably the biggest area where guidance from the legislature would be very helpful. What kind of things that we might capture on body camera are we all as a society deciding is really too much of an invasion of someone's privacy? And what is it that we really want to see? I mean, essentially, can you police the police by looking at body camera? Absolutely. But you don't necessarily need to know what's in someone's house or in the background to do that. And I think that's really the guidance that's missing in Maryland and that many states are looking to shore up.
Right. And, Hilary, I think we've gone through a lot of the things that I think we all agree should never be released to the public. So kids, sensitive information, graphic images, anything like that. Officers also record private conversations. That stuff should not be released to the public. It's of no benefit. But then you get into the gray area, I think, what you're talking about. Let's say, someone goes to Michael's house and Michael has 5 Picassos on the wall, right? Like now somebody has to sit there as a custodian and think, wait a second, if I release this, people are going to know that he has really, really valuable artwork. And is that something that I should be releasing and telling people, like, go to this guy's house and steal these Picassos? Like, that's the kind of gray area, I think, where there is flexibility. But then you, as a custodian or any custodian, has to make that decision. Is this worth it? Is this going to result in his house being broken into? Do people need to know that he has an art collection like this? So these are the gray areas, right, where we have to make tough decisions. And I think guidance from the General Assembly is warranted. But there are a lot of those instances, Hilary, where somebody has to make a really tough call, and you can't look at the law and you don't have, nuts and bolts wise, a clear law about what can you release. Like, there's nothing in the law that says, hey, don't release a priceless art collection. Don't show that to the public. You have to make that call.
Well, right. Absolutely. And, it's the way the wording in the statute is unwarranted. Okay, well, what's warranted in this situation? And again, it may make a lot of sense to have government flexibility when what I'm redacting is a confidential source or there's no arrest yet. I mean, that's the kind of flexibility that the government's always had and wants to preserve. But we're seeing now with body cameras across the country that every state is facing this same world of picking up on a government record a bunch of information about things we would never have written down. What is it that we as a society believe is unwarranted as an invasion of privacy and what shouldn't be disclosed? And that's really the guidance I think people are seeking. And it's really due to the fact that this is a dynamic record, really doesn't look or quack at all like its paper counterpart.
Right. So I feel like the picture's coming in clearer focus for our listeners who have come with us this far. Now I think you see why this is so vexing. Kevin and I tried to do our 6-minute treatment of this topic and say, hey, this is challenging. But Hilary, you've helped us get this more in focus. You can understand why victims' rights groups have been really active with us in Annapolis saying, we want to make sure these things are, we want them to be for sure denials. We want them to be mandatory denials that, information that portrays or shows victims of crime or violence. That's the sort of thing that they basically are saying, don't leave that as a judgment call. Don't make it only if it's an unwarranted release. The public doesn't need to see the battered face of a victim, right? Or the children and so forth. That's the idea of, if we want the state law to reflect reality more reasonably, you need to pass a bill, change what the state law says is on the, yes, you must divulge this. No, you must not divulge that. And how do you deal with a request that is kind of open-ended, right? That's part of this too. I guess we should say that as we talk about the Public Information Act, we're not talking about, say, someone who accuses an officer of wrongdoing and is filing suit or something of that nature. There's a whole separate process for people to get access to body camera footage if they're filing a claim or a complaint or they have a lawsuit or something along those lines. this is different. The Public Information Act is just one way that information can get into people's hands. This is about sharing it with the public as opposed to the affected parties, right?
Absolutely. And the criminal process, the defense attorneys, the prosecutors, their access to body camera is never redacted.
Right.
I mean, it's actually, in fact, most of the body camera software out there gives a clear chain of custody report and makes it, crystal clear to the court and to all the parties that it isn't tampered with and that it is a accurate reflection of what was recorded. And that's so important for the criminal case and same for civil. So that whole process is not what we're talking about. As you said, this is literally your press requests, your nosy neighbor, your, nonprofit or whomever that wants to see this body camera footage. That's the group in which these exemptions to disclosure are really thought about. What should the public that isn't involved in the trial, isn't involved in the criminal or civil aspect, what can they see? And I think that, flexibility, like you said, for government is fine. But we're at the point as government lawyers where it's very difficult to anticipate what's going to be captured on these body camera videos and what is it that we as a society want to see. And I think it's fairly clear many, many other states are struggling with this, and many states have instituted rules to help guide them about what kind of things are just not available for public consumption. Or alternatively, what things must definitely be available. For example, many states say, look, if this is showing, police brutality, if it's showing, police misconduct of any kind, that's a must disclose.
Right.
So the reality is that states have approached it both from the what you're not allowed to disclose or what you must disclose, but there's a lot more guidance out there than Maryland has at the moment.
Right. And, you mentioned nosy neighbor, you mentioned just, that is an important distinction. If you're filing suit and there's some claim, then that's a separate process. But nosy neighbors, the last thing we want is for this kind of stuff to get on social media and people to be shamed. And that's a whole nother element that we have to protect against and you have to think about. It's also important to note that going through this footage, through video footage, takes a lot of time, right? An attorney needs to review every second of that footage to make sure that the kind of sensitive information we're talking about has been redacted. And for a major incident, you may review a lot of body camera footage from multiple officers, right, to comply with one request. So if you have multiple officers responding to a major incident, all of a sudden now you just multiply the amount of footage, tenfold in some circumstances. And I know in Baltimore City, Hilary, I've heard you say that you had one request that required over 1,300 hours and $700,000 to fulfill. So that's how much money it costs the city to have attorneys go through, review the footage, redact the footage. And I assume that was from a major incident. But talk a little bit about that process and how that can be cumbersome. And again, it's expensive. And that's just a reality of this conversation.
Well, I think that is the reality. If we had unlimited resources and people to review the footage, that would be different, but we don't. And one of the things that enumerated exemptions in the law does is by default, it makes the job faster, quicker, easier, cheaper. I know that I cannot let out medical information. I don't have to review cases about it. I don't have to try to decide, well, is this person really going to be harmed by the release of this? The General Assembly has made that distinction for me, and thus the cost is exponentially less. Yes, there have been extremely expensive requests for body camera and police record requests in the city. And part of it is because people don't necessarily want just one incident. Understandably, they want a whole smattering of incidents as a way to say, look, this is the pattern in the practice of the police department. We're interested in what do they generally do most of the time. And so there's clearly a public desire to see not only body camera footage, but many of the police records that have to do with police discipline. And I know, at least for Baltimore City and every other police department in the state whose representatives I've talked to, everybody wants that information out. Mm-hmm. We're all on that page. What we're struggling with is the stuff that you wouldn't even believe is caught in the background or is left in these records that really has nothing to do with what the government's doing. It's not really about the police officer. And, I think that's the part that people are struggling with. Even if you get really great software, and it has the capability of clearly excising or blacking out the things you don't want seen, you still have to sit there, like you said, and review every second of that footage to make sure. And you're looking at the whole thing, foreground, background, middle ground, it's a really time-intensive process, and it makes the costs go up. And it's not necessarily a well-spent dollar, because if we as a society could agree on what the rules were for that background information, then we wouldn't be spending that money as a society, whether it's the requester or the government, on trying to go through bit by bit. We'd have better guidance, which would be cheaper for everyone and really advance transparency, because it would allow us to get more information that everyone wants to see out more expeditiously.
Right. And I think, one of the things there is, look, we want to do this the right way, right? But we're dedicating resources to things that shouldn't be released and ultimately maybe decided aren't going to be released. But I think one of the things too, like we talked about quote unquote phishing expeditions, and we know these First Amendment auditors, that's a new thing, right? Where they show up and they may request information, or they're filming inside of an office and they're just looking to stir the pot in most instances. But if I walk in and say, I want all the footage from these officers for a week, or I can even refine it some, but still it's a massive amount of information, and you still need to deal with that in some respects, right? You still need to go back and look, okay, well, how much footage is it? What do we need to do here? Like, that takes time. So trying to prevent these kind of phishing expeditions that really are just meant to portray someone in a negative light. There's nothing specific that someone's looking for. There's no specific instance. Like, we know that happens, and we know that happens in a lot of cases, and not just in Baltimore, across the state. This is on the uprise, and people are just looking to get this stuff out there, and whatever their intentions are, they can come in and ask for a lot of footage, and you still need to deal with that. So I think it makes a lot of sense when you say, look, if we had more clear laws, if the laws were written more clearly and we had a better indication of what we can and can't do, and there wasn't so much ambiguity, it would save time, it would save money, and these are public dollars that are, being expended to go through this. And again, in some instances, for no reason, because that stuff doesn't ended up getting released or whatever the case may be. But these are public dollars that could benefit the public in better ways than, throwing it away because you have to deal with some phishing expedition. Am I on point there in terms of what the issue there is?
Yeah, but, taking the other side, I am much better off with a massive phishing expedition, as you called it, if I know which things need to be redacted out and which ones don't. Even that quote unquote phishing expedition, which, to us seems, that perhaps there's no good reason for it. And to media or, government watchdogs, they think it's a really great idea to ask. Regardless of that, no matter where you stand on that spectrum, better and more succinct laws that clearly state what can't be disclosed in these body cameras will make everything cheaper, whether you've got a phishing expedition or not. And I think what is very troubling is, look, we're a government. We can't just decide as perhaps a private party to go spend money in a certain way without oversight, or, move money from one place to another when a massive record request comes in. If an agency hasn't budgeted for the time for attorney review and, government employee or outside contractor review, they're stuck with a massive amount of work that they didn't plan for and they perhaps haven't budgeted for. You simply can't just go, oh, okay, well, it turns out, I'd like to take this money where we were going to buy pens and pencils and we'll just redirect it over here. Most governments don't have that flexibility, and for good reason. People are supposed to decide in advance how the money's going to be spent and on what. And so certainly in Baltimore City, we've had many instances where we have to employ outside counsel and we get an outside counsel bill. And the question is, who's going to pay for that? The public, if we eat some of that cost, or the private requester? And the answer is it'd be great if the bill wasn't that high, regardless of who pays for it. If we could have a much faster and more streamlined process, then the cost comes down no matter who pays for it.
Yeah, in an economics class, I used to teach one, and we talked about transaction costs being a part, sort of why the world doesn't run as smoothly as in these super simplified economic models because of things like transaction costs. And it's not sexy and exciting, but it does take skillful human beings to go frame by frame through video footage to make these judgments. And like you said, having clear rules for balls and strikes benefits both the requesters and the custodians by probably, limiting the amount of judgment and the amount of decision making that has to go into, here's what we can offer you. It's going to have to, we're going to have to go through this redaction process. It's going to be difficult, but at least we know what the rules of the game are there. So, I mean, that really gets us to what we're trying to do with the bill that we plan to once again put before the General Assembly, is try and firm up that a clear list of things that should not be disclosed if they happen to be contained in body camera footage. But then we continue to preserve your right to get the footage if you're an affected party, if you or your family member are affected by the incident that the footage is of and so forth. We want to make sure that those people they retain their access. This doesn't shortchange your ability to get what you need to pursue litigation or a court case. It doesn't affect the discovery process. All those sorts of things are unaffected. This is just in the generic, clearer rules on what stuff ought not be shared, more clear guidance to the custodians, and try and bring down these transaction costs, particularly when there are broad and wide requests.
Absolutely. And I think you've really hit the nail on the head on transaction costs. A lawyer's time is more expensive than a paralegal, for example. And even if I had to contract out a massive body camera review to an outside counsel, I'm going to get a much lower bill if there isn't legal analysis that's needed. And instead, someone's watching footage and literally saying, okay, this shows a dead body. I don't have to make a judgment call, dead body redacted. Or this shows someone's home, black out the background. Or this is something of a sexual nature. This is what gets redacted. Or here are the minors. This is what gets redacted. That is a direct reduction of cost if we can all agree on those kinds of things that we are not interested in disclosing publicly. Again, like you said, they go into the criminal world or the civil lawsuit world without redaction. But for public consumption, we're just going to all agree nothing comes from seeing a nude body or seeing the inside of a school or all sorts of other exemptions that other states have adopted that really help determine what should and shouldn't be seen. And, it's worth repeating that in 2015, there was a special commission to amend the Public Information Act, and their recommendation was a statute to determine what parts of these videos should be released. And they were specifically concerned about victims of violent crimes and domestic abuse and making sure that there wasn't any government discretion so that you're not in a world where there's any choice. And really, the government doesn't want a choice on that. And I'm not sure the public does either. I don't think you want us spending our time going through and trying to determine in each instance, is there going to be a public problem? Is it in the public interest to release? We're sort of begging for General Assembly guidance. And really, that was what best practices suggested in 2015.
It's a fascinating issue, and obviously it's made it to, MACo's walking around sheet as one of our top 4 initiatives. We know, Hilary, too, that storage can be very expensive. Storing all this footage, this is massive amounts of data, and that has to stay on servers somewhere, and you have to protect it against, cyber attacks and whatnot. So that's another issue, too, that I think we can talk about another time. But certainly there are a lot of moving parts here. Technology is advancing, but at the end of the day, the ambiguity here creates a lot of problems for many different reasons. I think this has been great, Hilary, and again, I think you are absolutely the right person to help us walk through this, and it's illuminating in many ways, and I think we're able to understand it more clearly and able to explain to our audience more clearly. Is there anything that we haven't gotten into, Hilary, that is important to you? I mean, you've seen iterations of this bill for years. You've been at the testimony table. You've heard the opponents. What is the big takeaway that you want our podcast listeners in county land and elsewhere to be you had to know this one fact or something that we've missed here that really needs to be said before we let you go?
Yeah, I would just say that MACo has faced, and certainly me as testifying on behalf of the city and for MACo, we faced a lot of pushback from groups like ACLU saying, these kinds of laws aren't needed because you can always protect the unwarranted invasion of personal privacy in these investigatory records. And I think that really is a reductionist argument. It simplifies too much what's required because it's been clear from Maryland's highest court that there is no definition for unwarranted invasion of privacy in the law. And that leaves lawyers looking at the Constitution, cases on Maryland's Constitution, on generally the right to privacy. And it's a very difficult world when you're stuck going through those cases. And I think that's why most states have decided not to do that. They've decided instead to come up with a list of things that we have decided is just not what we expect the public to view in these body cameras. And I think, Maryland has sort of lagged on this for 5, 6, 7 years now because, it really should be something that our elected officials decide, what kinds of things are just too much of an invasion of privacy on these videos. And, I think it's not fair to say, well, the law gives the government the option. Yes, we acknowledge that. We have the option to protect those things now, but we want the guidance. We want that guidance so that we're not sort of trolling around in case law, but we're really releasing only what the public has decided is really in the public interest.
Yeah, I think that's well put. And look, this is practical. This is not about trying to withhold footage that should be released to the public or to anyone else. It's not about that. It's about trying to refine this process and make it better, make it easier so that everybody can be on the same page and there aren't these tough calls that need to be made, especially because Maryland law holds individuals responsible. So, certainly I think this makes a lot of sense. We're going to push hard in the next session of the General Assembly. I'm sure, Hilary, you will be down in Annapolis talking about this bill, and we certainly appreciate that. But this was great. We really appreciate your time today, and thank you for taking it. And I'm hopeful that we get this around and everybody can listen and understand what this initiative is all about and what it's not about. And thank you so much for joining us.
Absolutely. And I think just to that point, all of the bills that MACo's put forward in the past have been clear that what we want to see is police misconduct, arrests, detentions, seizures, that kind of thing. So just as much as we've talked about what not to see, we've certainly said we're all on board for transparency and what we do want to see. But having a clear yes and no column essentially in the law is going to really reduce the costs that this places on local governments and also the stress on each individual record custodian to try to evaluate all these different scenarios.
And of course, protect all that sensitive information. And that's why we've had a coalition of victims' right groups with us at the stand testifying in support of this bill. And I think all these things are needed and necessary. So Hilary, again, thank you so much. If you enjoyed the podcast, please go ahead and subscribe. That way, all these episodes will be sent directly to the device of your choice. You can also follow along on social media, Facebook, Twitter, and then, of course, on the Conduit Street blog. But for Hilary Ruley and Michael Sanderson, for our producer, Victoria Moss, this is Kevin Kinnally signing off, and we will talk to you soon.